Reaffirmation agreements in bankruptcy. The primary thrust of Chapter 7 bankruptcy cases is to deal with consumer debts in such a manner as to ultimately discharge them, i.e., eliminate the obligation to pay certain types of debt and get a financial fresh start. While not all debts are subject to discharge, many of them, primarily consumer debts, are. There are some circumstances where a debtor opts to continue to service certain debts that may be otherwise dischargeable in Chapter 7 bankruptcy proceedings. Being involved in a bankruptcy case does not prevent a debtor from voluntarily agreeing to paying a debt that would otherwise be dischargeable in the case. When a debtor agrees to pay an otherwise dischargeable debt, the transaction is contractual. To have a binding contract in such an instance, the debtor and creditor enter into a reaffirmation agreement, whereby the debtor reaffirms his or her intention and willingness to pay what is owed the creditor on the other side of the agreement. Why pay an otherwise dischargeable debt? The most common scenario where a debtor might choose to reaffirm an otherwise dischargeable debt is when a creditor holds a security interest on the property of the debtor. The property may be an automobile, a major appliance, or other substantive commodity, or it may be a mortgage on real property. A common thread with such property is a purchase over time with periodic or recurring payments. A creditor's security interest protects the creditor if the debtor possessing the collateral is unable to pay the debt. In most cases, at some point, the creditor usually has the right to take away and sell the property if contractual payments are not made. Bankruptcy does not erase or wipe out a valid security interest. If a debtor in bankruptcy wants or even needs to keep property subject to another security interest, he or she will likely agree to executing a reaffirmation agreement that pertains to that asset. Such an agreement obligates the debtor anew to terms of payment and repayment agreeable to the creditor. Like any contract, reaffirmation agreements must meet the 6 basic requirements for a valid agreement: offer, acceptance, party competence, lawful subject matter, mutuality of obligation, and consideration. Another reason a debtor might agree to a reaffirmation agreement is when a security interest has more than one obligor, such as a case where a debtor in bankruptcy has an automobile on which there is a co-signer or guarantor. In Chapter 7 bankruptcy, a discharge is something that is available solely to the debtor. The discharge of obligations does not have any effect on the obligations of others. In most instances, a co-signer is liable to continue to make payments or suffer repossession upon the default of the primary debtor. With a reaffirmation agreement, the debtor is lifting the onus off the co-signer guarantor. Advantages and disadvantages of reaffirmation agreements. Reaffirmation is anti-ethical to one of the primary purposes of bankruptcy, which is to give the debtor a clean financial position or restart. At the same time, reaffirmation can be very useful to debtors who really need to retain possession of an item, as in the example above, an automobile, perhaps. 2 advantages of reaffirmation are: it allows the debtor to retain possession of an item, and it avoids the necessity of coming up with funds to redeem full ownership at a given point. On the other hand, some disadvantages of reaffirmation are: it leaves the debtor stuck with the debt and potentially liable for fees and costs over and above the amount of the debt. There's the potential for repossession of the security. and the debtor has only one shot at discharge when bankruptcy is filed. Reaffirmation forecloses future discharge of a certain debt in bankruptcy for at least 8 years. The decision to reaffirm is a serious one. Bankruptcy professionals recommend reaffirmation of an otherwise dischargeable debt only if 1. A debtor really can't afford, for whatever reason, to live without the property. 2. A debtor can't afford to redeem the property outright at a given point. And 3. The creditor will agree to accept the current value of the property as payment in full on the property, even when the debtor owes more on the property when initiating bankruptcy. As a footnote, generally, creditors know that if a debtor does not reaffirm, they will have to repossess, store, and sell the property. Creditors also know that such costs may be even more than the current value of the item. It makes sense for many creditors to agree to reaffirmation. When assessing advantages of reaffirmation, a debtor should consider need versus want. Wanting something is much different than needing something essential like an automobile needed for work or a livelihood. A wanted item is not a good reason for reaffirmation. A needed item may certainly well be. Item replaceable for less money. With dischargeable debt on an item such as an automobile, a cheaper, more affordable replacement may be a reason for going forward with discharge versus reaffirming a debt that, in the end, may be at a significantly greater cost. What can the debtor really afford? Reaffirmation agreements carry personal liability for the reaffirming debtor. If the debtor defaults after agreeing to reaffirmation, a car with a loan on it of $20,000 may be only worth in a repossession or sale significantly less, say $10,000. With personal liability, the debtor in the above scenario might be liable for the additional $10,000 or in total $20,000 when the loan is just for $10,000. In this instance, the debtor should avoid reaffirmation, discharge the debt in bankruptcy, and buy a less expensive, more affordable replacement automobile. New deal from creditor. For the debtor considering reaffirmation, affordability is the key. Even under a better deal offered by a creditor, a debtor cannot afford to make periodic regular payments. Reaffirming a debt by agreement is not advisable. Real property and mortgages. Personal property, an automobile, appliance, etc., is treated differently than real property subject to a mortgage. When payments on either are current, the bankruptcy code makes clear that a debtor who has placed personal property in bankruptcy must reaffirm if she or he wishes to retain it, even if the account is current and not delinquent. With respect to property subject to a mortgage, a debtor current and not delinquent can retain the property without reaffirming the original loan in place. It's called riding a debt through bankruptcy or riding through. No delinquency at reaffirmation. A debtor considering reaffirmation should be up to date on obligations or make sure that he or she is able to catch up and become current prior to reaffirmation. The position of a co-obligor or guarantor. Is the debtor a borrower? Is the debtor a guarantor? If the former, the advantages of reaffirming are twofold. One, as a borrower, it allows the debtor to keep the property. Two, it protects the co-obligor or guarantor from having to pay. Now, if the debtor is a guarantor and the co-obligor is the borrower, it is a different situation because a discharge would not necessarily mean repossession. It would reduce the creditor's security for obtaining repayment if the borrower should default. If a debtor does not care if property is repossessed from the borrower, no reaffirmation should be agreed to by the debtor. Repossession considerations. If a creditor has the right under an agreement to repossess the property subject to an agreement, a secured debt, then an agreement reaffirms a creditor's right to repossess upon default. Here, again, a want versus need assessment is in order. Improving a credit rating. A debtor should not enter into a reaffirmation agreement solely for the purpose of improving a credit rating. Effects of agreeing to reaffirmation and timing. A debtor who enters into a reaffirmation agreement is obligated to pay the reaffirmed debt, with such debt being treated as if the debtor had never filed for bankruptcy. The process of reaffirmation of debt can have serious financial consequences. Staying with the auto purchase example, a debtor who has signed a reaffirmation agreement concerning the car loan can face a repossession or be sued in court for the loan's balance for a failure to make payments on the reaffirmed debt. What's more, if a debtor cannot pay the reaffirmed debt, he or she must wait 8 years after filing for bankruptcy before filing again to discharge the reaffirmed debt. Understanding the terms of the reaffirmation agreement is paramount. A debtor should know and understand the following: the total amount owing on the reaffirmed debt, the timing of the payments on the debt, and the rights of the creditor to repossess or take away the property in case of default. A reaffirmation agreement can only be entered into during pendency of bankruptcy proceedings and before the granting of a discharge. Reaffirmation agreements are filed with the clerk of the bankruptcy court, and filing requirements are strict. An executed reaffirmation agreement may be filed by any party to the bankruptcy proceedings, including the debtor or a creditor withstanding in the matter. The agreement must be filed within 60 days after the first date set for the first meeting of creditors, unless the deadline is extended by the court. Parties and creditors receive written notice of the first meeting of creditors. A debtor does not have to be represented by an attorney to be eligible to file an executed reaffirmation agreement. If represented, however, the debtor's attorney must certify in writing that the client has been advised of the legal effects and consequences of entering into a reaffirmation agreement, including the effects of a default under the agreement. The process is slightly different if the debtor is not represented by an attorney and is appearing pro se. The pro se debtor will receive notice of a hearing upon or shortly after filing the reaffirmation agreement with the court. At the hearing, the debtor explains to the court his or her reasons for wanting to enter into an agreement and how he or she can afford to make payments on the reaffirmed debt. Except for certain circumstances related to reaffirmation of real property debt, the bankruptcy judge must approve the reaffirmation agreement with findings that it is in the best interest of the debtor and will not impose an undue hardship on the debtor or his or her dependents. It's also possible for a debtor to cancel an executed reaffirmation agreement. An agreement can be canceled by the debtor by the later of 1. The issuance of a discharge in the bankruptcy proceedings, or 2. 60 days from the date the reaffirmation agreement is filed with the bankruptcy court. Denial of reaffirmation. When a debtor lists his or her debts in bankruptcy, it is with the expectation that those will be erased upon obtaining a bankruptcy discharge. That is a major advantage of debtors going through Chapter 7 bankruptcy. Reaffirmation of a listed debt, or debts, means that the debtor plans to pay those off. However, a debtor who can't pay a reaffirmed debt runs the risk of being sued and having wages garnished and assets attached. In some instances, a denial of reaffirmation may be in the best interest of a debtor. An example of denial being in the best interest of a debtor is where an automobile has a trade-in value or other value of, say, $10,000, but the outstanding debt, as noted earlier, is, say, $20,000. While the value is $10,000, the debtor still rightfully owes the $20,000 balance. In such a case, it would not make any sense for the debtor to reaffirm, and it is a likely scenario where the court would deny reaffirmation and where an attorney would be strongly advised to advise his client against it. Likewise, where a debtor's income is insufficient to pay monthly bills after going through a bankruptcy, the court is unlikely to allow reaffirmation of some debts where it is clear beforehand that a debtor will not be able to make periodic, regular payments against the debt. A bankruptcy court is unlikely to reaffirm debts where there is clear evidence of a likely future default with negative consequences for the debtor and/or his or her dependents. In both instances noted above, a court will likely act to deny reaffirmation in order to prevent future financial difficulties for a debtor. In the same vein, a debtor's attorney is duty-bound to advise against a reaffirmation agreement that may be harmful to the interests of his client. The introduction of means testing as part of the 2005 bankruptcy reform made it more difficult for debtors to reaffirm loans and other debts. Under means testing standards, a debtor must certify that entering into a reaffirmation agreement will not create a hardship for the debtor or his or her dependents. In post-2005 Chapter 7 proceedings, qualifying to file is an indication that a debtor passed the means test and a median income test, or allowable expenses lowered a debtor's income enough to qualify. That means adding additional debt after close of bankruptcy may be, on its face, a hardship. If so, that is enough reason for the court to deny reaffirmation of debts that could contribute to such hardships. Reaffirmation of a mortgage. A mortgage on real property is a secured debt. The security is the property covered by the loan. Filing for bankruptcy does not change the nature of the mortgage obligation if the debtor wants to retain the property. There are both pros and cons of reaffirming a mortgage in Chapter 7 bankruptcy proceedings. In a Chapter 7 bankruptcy, the debtor is required to list all debts and assets, including real property. The court issues a stay, banning any collection activity or lawsuits by a debtor's creditors, and then assigns a trustee to liquidate the debtor's assets to pay any secured debts. A mortgage is a debt secured by the covered property. Unsecured debts are discharged at the end of the process, which results in a financial clean slate, as noted earlier, for the debtor in bankruptcy. The laws of the states govern which property is exempt from seizure by the trustee. In all 50 states, a personal primary residence is exempt and safe from foreclosure. Safe from foreclosure, that is, until the bankruptcy discharge. Like any other reaffirmation agreement approved in bankruptcy, such an agreement with a home mortgage company means that the debtor agrees to continue making payments on schedule and on time while continuing to occupy the residence. Since the lender has a security interest in the home, a default after bankruptcy means that a debtor risks foreclosure with or without a reaffirmed mortgage. One pro of continuing to make payments is that the lender reports favorably to the 3 major credit reporting agencies, a sure way to improve a credit score after leaving bankruptcy. On the downside, however, is the risk of being a debtor with shaky finances in the first place and then defaulting on a loan, reaffirmed or not. Non-payment on a residential mortgage is likely to lead to foreclosure and loss of a residence. Under the same scenario with a reaffirmation agreement that is enforceable, the debtor may lose the home and continue to be liable for some, or in many cases, all of a remaining balance depending upon the terms of the agreement. Most analysts agree that reaffirming a mortgage is not generally advisable for a debtor exiting bankruptcy. At best, it would represent a courtesy to the mortgage lender in the form of additional security. In exchange, the lender with a reaffirmed mortgage is likely to continue to report favorably to credit agencies, but other than that, there's not much of an upside to a debtor in reaffirming a mortgage. Conclusion. Debtors should be careful and well-informed when considering whether to agree to reaffirm a secured debt in bankruptcy. Observers and analysts mostly agree that, in general, debtors should not reaffirm any debts in most instances. A debtor should not reaffirm any debt that they cannot afford to make regular periodic payments on over the long haul. Likewise, a debt should not be reaffirmed unless it covers something that a debtor absolutely cannot afford to live without. A major primary pitfall for a debtor opting to reaffirm a secured debt is that personal liability attaches with the making of the agreement. Using the automobile loan as an example, a debtor can go from a position of merely having the car possessed after a default to the point of having to pay all the outstanding debt beyond the value of the car due to having personal liability resulting from an enforceable reaffirmation agreement. My last word, caveat emptor.